Terry v. Ohio, Supreme Court, 1968. Chief Justice Warren delivered the opinion of the court. This case presents serious questions concerning the role of the Fourth Amendment in the confrontation on the street between a citizen and the policeman investigating suspicious circumstances. Petitioner Terry was convicted of carrying a concealed weapon and sentenced to the statutorily prescribed term of 1 to 3 years in the penitentiary. Following the denial of a pretrial motion to suppress, the prosecution introduced in evidence 2 revolvers and a number of bullets seized from Terry, the co-defendant, Richard Chilton, by Cleveland Police Detective Martin McFadden. At the hearing on the motion to suppress this evidence, Officer McFadden testified that while he was patrolling in plain clothes in downtown Cleveland at approximately 2:30 in the afternoon on October 31st, 1963, his attention was attracted by 2 men, Chilton and Terry, standing on the corner of Huron and Euclid Avenue. He had never seen the 2 men before, and he was unable to say precisely what first drew his eye to them. However, he testified that he had been a policeman for 39 years and a detective for 35, and that he had been assigned to patrol this vicinity of downtown Cleveland for shoplifters and pickpockets for 30 years. He explained that he had developed routine habits of observation over the years, that he would stand and watch people or walk and watch people at many intervals of the day. He added, "Now, in this case, when I looked over, they didn't look right to me at the time." His interest aroused, Officer McFadden took up a post of observation in the entrance to a store 300 to 400 feet away from the 2 men. "I get more purpose to watch them when I see their movements," he testified. He saw one of the men leave the other one and walk southwest on Huron Road past some stores. The man paused for a moment and looked in a store window, then walked on a short distance, turned around and walked back toward the corner, pausing once again to look in the same store window. He rejoined his companion at the corner, and the 2 conferred briefly. Then the second man went through the same series of motions, strolling down Huron Road, looking in the same window, walking on a short distance, turning back, peering in the store window again, and returning to confer with the first man at the corner. The 2 men repeated this ritual alternately between 5 and 6 times apiece, in all roughly a dozen trips. At one point, while the 2 were standing together on the corner, a third man approached them and engaged them briefly in conversation. This man then left the 2 others and walked west on Euclid Avenue. Chilton and Terry resumed their measured pacing, peering and conferring. After this had gone on for 10 to 12 minutes, the 2 men walked off together, heading west on Euclid Avenue, following the path taken earlier by the third man. By this time, Officer McFadden had become thoroughly suspicious. He testified that after observing their elaborately casual and oft-repeated reconnaissance of the store window on Huron Road, he suspected the 2 men of casing a job, a stick-up, and that he considered it his duty as a police officer to investigate further. He added that he feared they may have a gun. Thus, Officer McFadden followed Chilton and Terry and saw them in front of Zucker's store to talk to the same man who had conferred with them earlier on the street corner. Deciding that the situation was ripe for direct attention, Officer McFadden approached the 3 men, identified himself as a police officer, and asked for their names. At this point, his knowledge was confined to what he had observed. He was not acquainted with any of the 3 men by name or by sight, and he had received no information concerning them from any other source. When the 3 men mumbled something in response to his inquiries, Officer McFadden grabbed Petitioner Terry, spun him around so that they were facing the other 2, with Terry between McFadden and the others, and patted down the outside of his clothing. In the left breast pocket of Terry's overcoat, Officer McFadden felt a pistol. He reached inside the overcoat pocket, but was unable to remove the gun. At this point, keeping Terry between himself and the others, the officer ordered all 3 men to enter Zucker's store. As they went in, he removed Terry's overcoat completely, removed a .38 caliber revolver from the pocket, and ordered all 3 men to face the wall with their hands raised. Officer McFadden proceeded to pat down the outer clothing of Chilton and the third man, Katz. He discovered another revolver in the outer pocket of Chilton's overcoat, but no weapons were found on Katz. The officer testified that he only patted the men down to see whether they had weapons, and that he did not put his hands beneath the outer garments of either Terry or Chilton until he felt their guns. So far as appears from the record, he never placed his hands beneath Katz's outer garments. Officer McFadden seized Chilton's gun, asked the proprietor of the store to call a police wagon, and took all three men to the station, where Chilton and Terry were formally charged with carrying concealed weapons. On the motion to suppress the guns, the prosecution took the position that they had been seized following search incident to a lawful arrest. The trial court rejected this theory, stating that it would be stretching the facts beyond reasonable comprehension to find that Officer McFadden had probable cause to arrest the men before he patted them down for weapons. However, the court denied the defendant's motion on the ground that Officer McFadden, on the basis of his experience, had reasonable cause to believe that the defendants were conducting themselves suspiciously and some interrogation should be made of their action. Purely for his own protection, the court held, the officer had the right to pat down the outer clothing of these men, who he had reasonable cause to believe might be armed. The court distinguished between an investigatory stop and an arrest, and between a frisk of the outer clothing for weapons and a full-blown search for evidence of crime. The frisk, it held, was essential to the proper performance of the officer's investigatory duties, for without it, the answer to the police officer may be a bullet, and a loaded pistol discovered during the frisk is admissible. After the court denied their motion to suppress, Chilton and Terry waived jury trial and pleaded not guilty. The court adjudged them guilty, and the Court of Appeals for the 8th Judicial District, Cuyahoga County, affirmed. We affirm the conviction. 1. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The inestimable right of personal security belongs as much to the citizen on the streets of our cities as to the homeowner closeted in his study to dispose of his secret affairs. We would be less than candid if we did not acknowledge that this question thrusts to the force difficult and troublesome issues regarding a sensitive area of police activity, issues which have never before been squarely presented to this court. Reflective of the tensions involved are the practical and constitutional arguments pressed with great vigor on both sides of the public debate over the power of the police to stop and frisk, as it is sometimes euphemistically termed, suspicious persons. On the one hand, it is frequently argued that in dealing with the rapidly unfolding and often dangerous situations on city streets, the police are in need of an escalating set of flexible responses, graduated in relation to the amount of information they possess. For this purpose, it is urged that distinction should be made between a stop and an arrest, or a seizure of a person, and between a frisk and a search. Thus, it is argued, the police should be allowed to stop a person and detain him briefly for questioning upon suspicion that he may be connected with criminal activity. Upon suspicion that the person may be armed, the police should have the power to frisk him for weapons. If the stop and the frisk give rise to probable cause to believe that the suspect has committed a crime, then the police should be empowered to make a formal arrest and a full incident search of that person. This scheme is justified in part upon the motion that a stop and a frisk amount to a minor inconvenience and petty indignity, which can properly be imposed upon the citizen in the interest of effective law enforcement on the basis of police officers' suspicion. On the other side, the argument is made that the authority of the police must be strictly circumscribed by law of arrest and search as it has developed to date in the traditional jurisprudence of the Fourth Amendment. It is contended with some force that there is not, and cannot be, a variety of police activity which does not depend solely on the voluntary cooperation of the citizen, and yet which stops short of an arrest based on probable cause to make such an arrest. The heart of the Fourth Amendment, the argument runs, is a severe requirement of specific justification for any intrusion upon protected personal security, coupled with a highly developed system of judicial controls to enforce upon the agents of the state the commands of the Constitution. Acquiescence by the courts in the compulsion inherent in the field interrogation practices at issue here, it is urged, would constitute an abdication of judicial control over, and indeed an encouragement of, substantial interference with liberty and personal security by police officers whose judgments is necessarily colored by their primary involvement in the often competitive enterprise of ferreting out crime. This, it is argued, can only serve to exacerbate police-community tensions in the crowded centers of our nation's cities. Having thus roughly sketched the perimeters of the constitutional debate over the limits on police investigative conduct in general and the background against which this case presents itself, we turn our attention to the quite narrow question posed by the facts before us, whether it is always unreasonable for a policeman to seize a person and subject him to limited search for weapons unless there is probable cause for an arrest. Given the narrowness of this question, we have no occasion to canvass in detail the constitutional limits upon the scope of a policeman's power when he confronts a citizen without probable cause to arrest him. 2. Our first task is to establish at what point in this encounter the Fourth Amendment becomes relevant. That is, we must decide whether and when Officer McFadden seized Terry and whether and when he conducted a search. There is some suggestion in the use of such terms as stop and frisk that such police conduct is outside the purview of the Fourth Amendment because neither action rises to the level of a search or seizure within the meaning of the Constitution. We emphatically reject this notion. It is quite plain that the Fourth Amendment governs seizures of the person which do not eventuate in a trip to the station house and prosecution for crime. Arrests in traditional terminology. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person, and it is nothing less than sheer torture of the English language to suggest that a careful exploration of the outer surfaces of a person's clothing all over his or her body, an attempt to find a weapon, is not a search. Moreover, it is simply fantastic to urge that such a procedure performed in public by a policeman while the citizen stands helpless, perhaps facing a wall with his hands raised, is a petty indignity. It is a serious intrusion upon the sanctity of the person, which may inflict great indignity and arouse strong resentment, and it is not to be undertaken lightly. We have noted that the abusive practices which play a major, though by no means exclusive, role in creating this friction are not susceptible of control by means of the exclusionary rule, and cannot properly dictate our decision with respect to the powers of the police in genuine investigative and preventative situations. However, the degree of community resentment aroused by particular practices is clearly relevant to an assessment of the quality of the intrusion upon reasonable expectations of personal security caused by those practices. The danger in the logic which proceeds upon distinctions between a stop and an arrest or seizure of the person and between a frisk and a search is twofold. It seeks to isolate from constitutional scrutiny the initial stages of contact between the policeman and the citizen, and by suggesting a rigid all-or-nothing model of justification and regulation under the amendment, it obscures the utility of limitations upon the scope, as well as the initiation of a police action as a means of constitutional regulation. The scope of the search must be strictly tied and justified by the circumstances which rendered its initiation permissible. In our view, the sounder course is to recognize that the Fourth Amendment governs all intrusions by agents of the public upon personal security, and to make the scope of the particular intrusion, in light of all the exigencies of the case, a central element in the analysis of reasonableness. This seems preferable to an approach which attributes too much significance on an overly technical definition of search, and which turns in part upon a judge-made hierarchy of legislative enactments in the criminal sphere. Focusing the inquiry squarely on the dangers and demands of the particular situation also seems more likely to produce rules which are intelligible to the police and the public alike than requiring the officer in the heat of an unfolding encounter on the street to make a judgment as to which laws are of limited public consequence. The distinctions of classical stop and frisk theory thus serve to divert attention from the central inquiry under the Fourth Amendment, the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security. Search and seizure are not talismans. We therefore reject the notions that the Fourth Amendment does not come into play at all as a limitation upon police conduct if the officers stop short of something called a technical arrest or a full-blown search. In this case, there can be no question, then, that Officer McFadden seized Petitioner and subjected him to a search when he took hold of him and patted down the outer surfaces of his clothing. We must decide whether, at that point, it was reasonable for Officer McFadden to have interfered with Petitioner's personal security as he did. And in determining whether the seizure and search were unreasonable, our inquiry is a dual one: whether the officer's action was justified at its inception, and whether it was reasonably related in scope to the circumstances which justified the interference in the first place. 3. If this case involved police conduct subject to the warrant clause of the Fourth Amendment, we probably have to ascertain whether probable cause existed to justify the search and seizure which took place. However, that is not the case. We do not retreat from our holdings that the police must, whenever practicable, obtain advanced judicial approval of searches and seizures through the warrant procedure, or that, in most instances, failure to comply with the warrant requirement can be excused only by exigent circumstances. But we deal here with an entire rubric of police conduct, necessarily swift action predicated upon the on-the-spot observations of the officer on the beat, which historically has not been, and as a practical matter could not be, subjected to the warrant procedure. Instead, the conduct involved in this case must be tested by the Fourth Amendment's general prescription against unreasonable searches and seizures. Nonetheless, the notions which underlie both the warrant procedure and the requirement of probable cause remain fully relevant in this context. In order to assess the reasonableness of Officer McFadden's conduct as a general proposition, it is necessary first to focus on the governmental interest which allegedly justifies official intrusion upon the constitutionally protected interest of the private citizen, for there is no ready test for determining reasonableness other than by balancing the need to search or seize against the invasion which the search or seizure entails. And in justifying the particular intrusion, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant the intrusion. The scheme of the Fourth Amendment becomes meaningful only when it is assured that at some point the conduct of those charged with enforcing the laws can be subjected to the more detached, neutral scrutiny of a judge who must evaluate the reasonableness of a particular search or seizure in light of the particular circumstances. And in making that assessment, it is imperative that the facts be judged against an objective standard. Would the facts available to the officer at the moment of the seizure or the search warrant a man of reasonable caution in the belief that the action taken was appropriate? Anything less would invite intrusions upon constitutionally guaranteed rights based on nothing more substantial than inarticulate hunches. As a result, this court has consistently refused to sanction. And simple good faith on the part of the arresting officer is not enough. If subjective good faith alone were the test, the protections of the Fourth Amendment would evaporate, and the people would be secure in their persons, houses, papers, and effects only in the discretion of the police. Applying these principles to this case, we consider first the nature and extent of the governmental interests involved. One general interest is, of course, that of effective crime prevention and detection. It is this interest which underlies the recognition that a police officer may, in appropriate circumstances and in an appropriate manner, approach a person for purposes of investigating possibly criminal behavior, even though there is no probable cause to make an arrest. It was this legitimate investigative function Officer McFadden was discharging when he decided to approach Petitioner and his companions. He had observed Terry, Chilton, and Katz go through a series of acts, each of them perhaps innocent in itself, but which taken together warrant further investigation. There is nothing unusual in two men standing together on a street corner, perhaps waiting for someone, nor is there anything suspicious about people in such circumstances strolling up and down the street singly or in pairs. Store windows, moreover, are made to be looked in. But the story is quite different where, as here, two men hover about a street corner for an extended period of time, at the end of which it becomes apparent that they are not waiting for anyone or anything. Where these men pace alternately along the identical route, pausing to stare in the same store window roughly 24 times. Where each completion of this route is followed immediately by a conference between the two men on the corner. where they are joined in one of these conferences by a third man who leaves swiftly, and where the two men finally follow the third and rejoin him a couple of blocks away. It would have been poor police work indeed for an officer of 30 years' experience in the detection of thievery from stores in this same neighborhood to have failed to investigate this behavior further. The crux of this case, however, is not the propriety of Officer McFadden's taking steps to investigate petitioner's suspicious behavior, but rather whether there was justification for McFadden's invasion of Terry's personal security by searching him for weapons in the course of the investigation. We are now concerned with more than the governmental interest in the investigating crime. In addition, there is the more immediate interest of the police officer in taking steps to assure himself that the person with whom he is dealing is not armed with a weapon that could unexpectedly and fatally be used against him. Certainly, it would be unreasonable to require that police officers take unnecessary risk in the performance of duties. American criminals have a long tradition of armed violence, and every year in this country, many law enforcement officers are killed in the line of duty, and thousands more are wounded. Virtually all of these deaths and substantial portion of the injuries are inflicted with guns and knives. The easy availability of firearms to potential criminals in this country is well known and has provoked much debate. Whether the merits of gun control proposals, this fact is relevant to an assessment of the need for some form of self-protective search power. In view of these facts, we cannot blind ourselves to the need for law enforcement officers to protect themselves and other prospective victims of violence in situations where they may lack probable cause for an arrest. When an officer is justified in believing that the individual whose suspicious behavior he is investigating at close range is armed and presently dangerous to the officer or to others, it would appear to be clearly unreasonable to deny the officer the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. We must still consider, however, the nature and the quality of the intrusion on the individual rights which must be accepted if the police officers are to be conceded the right to search for weapons in situations where probable cause to arrest for crime is lacking. Even a limited search of the outer clothing for weapons constitutes a severe, though brief, intrusion upon cherished personal security and must surely be an annoying, frightening, and perhaps humiliating experience. Petitioner contends that such an intrusion is permissible only incident to a lawful arrest, either for a crime involving the possession of weapons or for a crime the commission of which led the officer to investigate in the first place. Our evaluation of the proper balance that has to be struck in this type of case leads us to conclude that there must be a narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer, where he has reason to believe that he is dealing with an armed and dangerous individual, regardless of whether he has probable cause to arrest the individual for a crime. The officer need not be absolutely certain that the individual is armed. The issue is whether a reasonable, prudent man in the circumstances would be warranted in the belief that his safety or that of others was in danger. And in determining whether the officer acted reasonably in such circumstances, due weight must be given not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. We need not develop at length in this case, however, the limitations which the Fourth Amendment places upon a protective seizure and search for weapons. These limitations will have to be developed in the concrete factual circumstances of individual cases. Suffice it to note that such a search, unlike a search without a warrant incident to a lawful arrest, is not justified by any need to prevent the disappearance or destruction of evidence of crime. The sole justification for the search in the present situation is the protection of the police officer and others nearby, and it must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. The scope of the search in this case presents no serious problem in light of these standards. Officer McFadden patted down the outer clothing of petitioner and his two companions. He did not place his hands in their pockets or under the outer surface of their garments until he had felt weapons, and then he merely reached for and removed the guns. He never did invade Katz's person beyond the outer surface of his clothes, since he discovered nothing in his pat-down which might have been a weapon. Officer McFadden confined his search strictly to what was minimally necessary to learn whether the men were armed and to disarm them once he discovered the weapons. He did not conduct a general exploratory search for whatever evidence of criminal activity he might find. 5. We conclude that the revolver seized from Terry was properly admitted in evidence against him. At the time he seized Petitioner and searched him for weapons, Officer McFadden had reasonable grounds to believe that Petitioner was armed and dangerous, and it was necessary for the protection of himself and others to take swift measures to discover the true facts and neutralize the threat of harm if it materialized. The policeman carefully restricted his search to what was appropriate to the discovery of the particular items which he sought. Each case of this sort will, of course, have to be decided on its own facts. We merely hold today that whether a police officer observes unusual conduct which leads him reasonably to conclude in light of his experience that criminal activity may be afoot, and that the person with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or other safety, he is entitled for the protection of himself and others in the area to conduct a carefully limited search in the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Such a search is a reasonable search under the Fourth Amendment, and any weapon seized may be properly introduced in evidence against the person from whom they were taken.